Great news, everyone. So U.S. Immigration, United States Citizenship and Immigration Services, just yesterday released the latest policy update on work permits. So the validity period for work permits for some categories or employment authorization documents, work permits for some people are going to be going up from 2 years to 5 years. So now if you are issued a work permit and you're within that category that I'll mention, then your work permit will be valid for the next 5 years. Okay, so if your work permit is issued in this year, 2023, then it will expire in 2028. That's wonderful news. Now, here's the background. If you're a non-citizen, that if you're not a green card holder or you're not a U.S. citizen, you must obtain work authorization or employment authorization in order for you to be able to work in the U.S. legally. Now, there are two categories of non-citizens. There are some classes of non-citizens who are allowed to work through their immigration status automatically. It's commonly referred to as employment authorization incident to status. The other types of non-citizens, those types of people are authorized to engage in employment, or they are allowed to work only if they proactively and affirmatively apply for work permits and they are granted work permits by U.S.CIS. Okay. So now let's get to the people who are going to be affected by this new policy update. So they are increasing the maximum validity period from 2 years to 5 years for both new, that's initial, and renewal work permits for people who are authorized to work incident to their status or circumstance. This includes people who are admitted as refugees, paroled as refugees, number 3, granted asylum, as well as people who have received the relief of withholding of removal. They are also, U.S.A is also increasing the maximum validity period to 5 years for new, initial, and renewal work permits. If you are renewing your work permits, EADs, for certain non-citizens that must apply for employment authorization. These include applicants for asylum, number 2, applicants for withholding of removal, number 3, people who are applying for adjustment of status under the INA section 245. That's the for example, if you are a beneficiary of an I-130 or a family petition, for example, that was filed before April 30th, 2001, then you can receive a green card through that process. But it's not the general adjustment of status as you know it. This is adjustment of status under INA 245 or under the Life Act. Okay, so please take note, this does not apply to all adjustments of status applicants. And then also people who are applying for suspension of deportation or cancellation of removal, they will also get work permits up to 5 years. Okay. Now, the guidance is also explaining that categories of non-citizens who are automatically authorized to work, they can present their Form I-94 to an employer to show that they are allowed to work in the United States. And normally when they do that, they also have to make sure that the Form I-94 is accompanied by an identity document or an ID, a valid ID card for purposes of work authorization or employment authorization. Again, they mentioned that certain Afghan and Ukrainian parolees are employment authorized incident to parole, meaning, there was chaos in Afghanistan when the Taliban took over Ukraine as well. There was a Russian war. And so the US said, okay, they were granting members of, nationals or residents of these countries. Well, yeah, the people who are from these countries, they were granting them parole to be able to enter the US to seek safety. So those people who have the parole, the parole that they were issued allowed them to work automatically. Okay. So the guidance is clarifying that as well. Now let's talk a little more about the policy highlights. The first policy highlight that we must note is that the guidance updates the maximum validity period for initial and renewal work permits from 2 years to 5 years for people who are admitted as refugees, people who are granted asylum, and people who are granted withholding of removal or withholding of deportation or removal. Number 2, the policy guidance is also updating, telling us about the fact that there's now it's updated the maximum validity period for initial and renewal work permits from 2 years to 5 years for people with pending applications for asylum, withholding of removal, and those with pending applications for adjustment of status under the INA section 245. Now, the third highlight of the update is that the policy updates the maximum validity period for initial and renewal work permits from 1 year to 5 years for those with, again, pending applications for suspension of deportation or cancellation of removal. The next one is that it updates the maximum validity period for initial and renewal work permits from 1 year to the end date of the authorized parole period, not to exceed 5 years for those paroled as refugees. Okay, so now if you're a parolee, if you are paroled as a refugee, then it will be from 1 year to the end of the date of your authorized parole period. But this validity will not exceed 5 years. That's a maximum. Then it lists the categories of non-citizens with employment authorization incident to status whose form I-94 is evidence of employment authorization, as well as of their immigration status. So as I mentioned, some people, when they are coming in, their immigration status already acts as a work permit for them, so they are automatically allowed to work. Others, if you come in, you need to affirmatively apply for a work permit and be issued the work permit before you can work. Okay, so that also clarifies that situation. And then the fact that you can use your I-94 as well as with a valid ID to show that you are allowed to work. And then it also explains that certain Afghan parolees and certain Ukrainian parolees are employment authorized incident to their parole. So this is very great news, very, very wonderful news, and kudos to everybody that made this happen. Now, USCIS clarifies that this update was actually initiated and inspired by some stakeholder feedback. So people from the public, it was an EAD related stakeholder feedback, and USCIS received response to a request for public input, an RPI. They requested that the public will, give their input or give their opinions on certain subjects, and specifically the RPI feedback suggested that USCIS should increase the maximum EAD or work permits validity period for certain categories. And USCIS has actually listened this time. They determined that it is certainly appropriate to issue revised guidance that will increase the maximum work permit or EAD validity period for the categories that have been discussed. And so it will just reduce the frequency or the how often the affected people would need to file for work authorization with USCIS if they needed to renew their work permit. So this is certainly wonderful news. So this is really going to help ease the backlog. It will help USCIS refocus their resources and attention on the cases that actually need to be adjudicated and decided on so things can move more quickly. The system was just clogged and choked with a lot of multiple applications from millions and millions of people applying year after year to renew their green card, their work permits. Now you will apply, and listen, like a year comes by really quickly. 2 years also comes by really quickly. You just renew the work permit, and then by the time you realize it's already 8 months and you're trying to renew it again and you're filing all these applications. So now it will give people the latitude 5 years. You can just enjoy your life, chill out, work, and then you see USCIS in the next 5 years. So now this policy update is already effective. It was effective from September 27th 2023 Wednesday, so it's already in effect. If you have any questions, drop them below. Follow me for more.